So welcome everyone. Welcome to a new panel within our lineup here at the Alberta Esports Association and for our Capsule Series event. So we're joined here with Field Law to support us in a new line of panels to talk about the legal perspective on issues within gaming and esports. So we're joined by Field Law, and they're our sponsor, and as well as a wonderful partner of ours. And they've been working with us for quite some time since our founding. And they've been an incredibly supportive group to help shape our organization from the back end. And of course, given our role at the Alberta Esports Association to really provide some level of structure and governance for the industry of esports at large as a kind of nascent and emerging space, what better way to have some support than from Field Law and their emerging technologies group. So I'll allow the two of them to introduce themselves, and starting with Erika.
Thanks, Victor. We are so excited to be participating in this capsule series and our first ever panel with AESA. I am a partner at Field Law and the chair of our emerging technology group. I'm happy that we're able to work with you because I think our group and your group has very similar approaches. Our emerging technology group tries to partner with industries like esports and partners like AESA because we want to take that industry first voice and community first voice and help them navigate some of the legal issues in this space that aren't well defined, and to remove barriers to participation and growth in the industry and position ourselves and partners like AESA as leaders in Canada.
No, that's awesome. That's like pulled right out of our vision, essentially, as our organization. And frankly, we are very thankful. Field Law did onboard themselves as an annual sponsor very recently to support us even further. But even for the last year and year and a half, they've been supporting us from the back end, and we're so grateful for that. And of course, we have Alex. Feel free to introduce yourself.
Hey, so my name's Alex Remondini, and I am a junior associate at Field Law. I'm actually going to be called to the bar in a matter of days here, just in early September, which is very exciting. Been a long time coming. But I'm a junior associate in our commercial litigation and intellectual property group, which is kind of what's brought me into our emerging tech group. And as part of my background before working with Field Law, I worked in Calgary with a lot of entrepreneurs, artists, photographers, and designers kind of, with their businesses and branding. So that's kind of given me a basis and as well as an interest in emerging technologies. So I'm extremely excited to be here and to be a part of this panel.
No, that's awesome, and I think we're so thankful to have the two of you as well. Understanding that esports is this new and emerging industry, particularly here in Alberta, it's very difficult to kind of navigate through this space and kind of understanding what that landscape actually looks like, especially when you're trying to operate as a business or an organization or even a professional player. It gets a little hairy. So I'd love to kind of dive right into some of the legal issues related to esports and gaming that we can dig into. Um, Erica, did you want to introduce kind of the first kind of sets of topics that you'd like to talk about?
Yeah, and when we first got involved with esports, there's some major issues that jump out that are typically in the area what that we'll be discussing today. But really, because esports is worldwide, it's global, it's multi-jurisdictional, that it impacts almost every area of law. And really fitting for us here in Alberta, it's commonly referred to as the Wild West of sports and entertainment law. So
Mhm.
that's really what ASA gets to deal with, and what we'll be helping you navigate it. But even despite it being the Wild West, it attracts billions of dollars of revenue, and so it is gaining so much attention right now. So from contracts to endorsements to players, leagues, and teams, all these participants in the industry really need to understand what types of legalities are implementing or impacting them. And this has been going on for years. It's newer here to North America, but Korea was the first to establish some of those guidelines and standards back in the 2000s, and later on the UK followed in later on being 2014, so 14 years later. Um, and here we are today, another 7 years later, still without any kind of standards or guidelines in North America or even in Canada. But really, what we're talking about, the main issues are intellectual property, so trademarks, copyright, patents. We're talking about gambling, betting. What are the rules and regulations in those areas? Contracts and the age of consent. We have players that are, not necessarily the age of majority. The age of majority is different worldwide, and we have players participating in many jurisdictions. How are they being paid? Another big issue for our group is, for example, the control of cyberspace and streaming capacities. There's a lot of different issues there about, can an internet provider in a jurisdiction control streaming capacities of an event? And so we've seen that in certain cases. What happens when a team or a group of players hacks another player's event? And so there's all kinds of issues there. And finally, we've seen issues with immigration law. So a lot of players who want to attend and compete in different countries are having difficulties getting visas because they don't fall under the typical category of athlete. So those are a myriad of issues that we're excited to discuss with AESA and its community over the next year, and see what we can do to help shape the regulations in Alberta and the strategy in Alberta that you're so involved in, and propel us forward.
Oh, it's so exciting to actually dive into this, especially because it being such a new space, and I'm sure many of the people who are watching right now can has like these questions in their mind already or have experienced some of these issues. I know for me, there's plenty of professional players that I love that are from are European, and they've been having challenges with visas to come over to North America and to the US to compete. And of course, given that it's their profession, there are some challenges around that. And it really does seem like with esports, it's like this merging of both the interactive digital media sector, but also the traditional sports sector. And of course, it has all the positives from both kind of industries, but it also carries a lot of the baggage and the challenges that are oftentimes underrecognized or even overlooked or not even thought about. In many cases, particularly with IP, one of the things that we talk about all the time, especially with governance or with schools that are kind of new within the esports space, is that there's a publisher or developer that owns the game in question that's being played competitively. And if you're to look at traditional sports like soccer or hockey, that's not owned by a single entity. And further on that, those games aren't also subject to immediate change. You're not going to get Hockey 2, the sequel, turbo mode, whereas in gaming, you see that all the time. And in some cases within the world of esports and gaming, oftentimes a publisher may discontinue the game. And now there's a game that's been played perhaps for 10 years, now discontinued, but there's still a player base and a fan base around that game. And what happens then when that game is off the shelves and no longer accessible? And I think that's a soft spot for many of the players within our community as well, because they are very active with some of these older titles that aren't being supported anymore. So these are some amazing topics. And as you can imagine, as Erika listed all of these out, there's a lot of ground to cover. And we only have one panel this weekend to talk about some of the topics. So definitely stick around, follow us on social media, and you'll be able to see more of their panels over the year as well.
Yeah, and I think that Alex is going to be well suited to dig into the areas that cover intellectual property with respect to gaming. And I'm excited at the end of the panel to sort of tease some of the changes that are coming to the law.
Yeah, for sure.
Yeah, I mean, like for me, IP is definitely where I kind of geek out. It's what gets me excited. But the interesting thing, so IP is extremely nuanced and complicated. And one of the biggest issues that I see is right away when I talk to people, they say, "Oh, well, you know what? I want to patent this," and what they're actually talking about is a trademark. Or they say they want to copyright something, but then what they're talking about it's maybe a patent or again a trademark. So I mean, with this, one of the biggest things that I want to touch on is, what is the difference between your different kinds of IP? What kind of IP can you get? And also, what is most applicable in the area of esports? So with that said, kind of the first thing I just want to touch on is trademark, which is going to be your branding. So at its essence, I mean, trademark can apply to a combination of words, sounds, designs, or colors. There's kind of a myriad of different things that trademark can actually apply to. And this is governed by the Trademark Act in Canada. So kind of your three basic ideas of what a trademark is going to be is you can either trademark a word, so that's called a word mark. So if you look at an example like, let's say, The Legend of Zelda, just the words The Legend of Zelda, that would be your word mark. But then you could also apply for a design mark on top of that. So yet again, when you think about The Legend of Zelda, they've got that kind of funky Z that either sometimes it has a sword through it or kind of a little switchblade in the little inner bit of it. that would be a design mark that you're then applying for to cover the style of those words. And then lastly, you can also apply for those in conjunction with one another. So you could apply for a word mark and a design mark, and there's a number of other things that you can apply for in the trademark world. That said, I don't think that that should be the main focus of today's topic, because that's more of a branding issue when you're starting out a company, that kind of thing. So what I really want to get down to is talking about copyright and esports. So with that said, the definition of copyright is the right to copy. I know that sounds extremely simple, but that's what it is. It is the right to copy. So by default in Canada, copyright is inherent. So for example, I write a haiku. That haiku has copyright because I wrote that. My artistic integrity is part of that. That said, it gets a little bit trickier. So something that you were talking about is, people being employed in e-gaming, or, they're working for a developer. So as soon as you're working for a developer, you're probably going to be contracted to work with them. And when you're working under contract, your IP rights, they change. And this is kind of a big exception to the rule of inherent copyright in Canada. So that copyright then, let's say I'm coding for one of the gaming giants. Whatever I make, it's not then my property. That's going to be the property of the gaming agency that I'm working for and that I'm coding for. So that's kind of a big thing to look out for, when you're creating for someone else. It's kind of a harsh reality that all of a sudden you could create the coolest game ever, but you don't have the copyright to it anymore. You still retain what are moral rights, but it's not the physical copyright, because that goes to whoever you're contracted to work for. So that's kind of like one of the big kind of humps or issues that I want to point out with copyright. The other thing is code is part of copyright, which doesn't seem like it should be, because a lot of people think, it's just, numbers, a combination of numbers, but there is artistic integrity in it because you're telling a story with your code, right? So anytime you're coding for a game, you're making then a story that underlies that game. But there's a little bit of a gray area in that. And I think that you had mentioned, Victor, that there's a lot of interest in modifying games. Is that right?
Yeah. So mods are definitely, tied closely with the community, whether it's just aesthetic, where they, change the outfit that Mario's wearing, or they completely adjust the coding itself, where the game itself is completely, blown up and plays completely differently than the original intent.
Yeah. So with that, so when you're then making these modifications, what happens is you're taking that original source code that's being used to make that original game. And this is where there's a little bit of a gray area. I like to use the analogy of music sampling, because I think it kind of directly parallels the idea of modifying games. So there is a certain leeway for artistic integrity and the creative process in copyright. And with that, I mean, historically, you look at music giants like Jay-Z, Kanye West, they use a lot of old music samples to create new music. So with modding games, it's kind of that same idea, where you're using something old to create something new. But then that poses the question, at what point is something considered to be new, and at what point is it simply just copyright infringement? So the courts have devised kind of this idea of substantial modification. And that brings us to the question, well, what then is substantial modification?
Where's the line? Yeah.
Exactly.
Probably not Mario's hat.
Exactly.
Yeah. Well, this is a very close to heart topic in particular, because we have a very active modding community within our community, and there's some indie developed titles that really kind of foster that. A really good example is Rivals of Aether, where they have an entire kind of workshop component to the game, where they invite the community to create their own characters using their core system, and so that's kind of fostered its own community. But in many cases, beyond just the the aesthetic of changing a character to look like a different character, there's some really popular titles that are based on substantial, or what I seem to think, substantial modification of an existing title to turn it into a new kind of entity, and there's a huge kind of community around that. But that there's a cease and desist that's been sent to the people who put these events together, and of course the original publishers don't like to acknowledge that modification exists, even though there's a huge kind of cult following for it. So this is close to
Yeah.
heart for sure for the community.
And it's kind of interesting because I say substantial modification, and that's kind of the issue is that it is a gray area because it depends at the end of the day. And, one thing, so that I want to mention, you mentioned, credit or consent for something. With copyright, I mean, the easiest way to get right to using that code without, having to jump through any of these substantial modification hoops is to simply ask for permission. But another myth that we kind of run into in the IP community is that credit does not equal consent. And one of these issues with consent is that, a gaming giant, they might not necessarily want their name tied to this modification. And if they don't want that, unfortunately, even if you credit them, it's not the same as having their consent, and they can still send a assist. Now, when it comes to substantial modification, so, if you're not going to be able to get this consent, the court has made some statement on what is a substantial modification. There's kind of a plethora of case law in the area of music, but there is a little bit that has started to emerge on code. And essentially what happened, there's this case, it's called IPC Global Party and Pavatest Party. And what happens in this is that an amount of the source code, a very small amount of the source code was taken, and they used it to develop something new. Now, a law test, or the legal test is then, what is substantial modification? And with this, they decided that it isn't the quantity of what's taken; it's what is the quality of that, and how integral is that to the original source code structure. So, despite the fact that it was only a very small amount of the source code that was taken to create this new product, they found that it was actually the integral part of the source code from the original product. So they couldn't consider it to be a substantial modification because to the average user, it was still identifiable as the original product. So at the end of the day, this then means that it's not about the amount. So I can't say that, 70% is, the magical number for substantial modification. If you could only take 10% of it, and it could still be infringement if it's seen to be substantial. And, in the area of music, they found that if it's taking the distinct traits of a song, then that's going to be considered to be infringement. If, the average person, who is kind of always our test in the law, is, what would a regular person that's inexperienced in the area kind of think? And if they were to be able to identify, this game as being the same as the original product, then there's a, potential that you have a case of infringement on your hands. So yeah, it's a tough area to say.
Yeah, it seems like it's pretty subjective,
debate.
case by case.
Yeah.
Like the line's not very defined, which makes it challenging for the community to kind of navigate through this space when they're, because I think the heartbreaking part of it all is that the communities themselves, like, it's the reason that they're engaged in modifying these games and adjusting them and to play them in their own ways, because they just love the game itself, and they're putting this much time into it. But then, it's a bit of a challenge.
We definitely had a debate though, because I think that the world of IP, so intellectual property, doesn't speak to specifically use in this context. So what I was asking Alex when we were debating this was, well, what happens when you have a game that's completely unusable and then someone makes it usable by adding or changing it, but it doesn't change the game. Like, the game is the game, but it was not usable. And I guess the portion of code or software or hardware that allows the game to be usable, Alex said, okay, well, maybe that in and of itself is patentable and or part of a copyright, but it doesn't mean that it erases the original copyright of the game. So I think that's where the debate is going to have to be for the world of esports, and where they're going to have to create maybe a new kind of precedent, is that there has to be some component of usability of the actual product. And if for some reason the code is now obsolete and not usable in the traditional or like the up-to-date functions, it can't be streamed online, it can only be used with an old Nintendo 64 or something like
Yeah,
that,
yeah.
then, you're no longer infringing because you created something completely different with a new
Did that happen
use.
to
But
everybody?
Yeah, and that's actually like a very again another close topic to the community as well, because one of the most popular titles is Super Smash Bros. Melee for the Nintendo GameCube, which was released in 2001. And of course, that's you're playing on a GameCube. There's no online capacities. You're playing on an old CRT. Both pieces of equipment are now discontinued. And so what the community has done now, they've ripped the ISO off of the disc, and now is able to play the game through an emulator. And not only that, but very recently they're able to create like a platform in which you could play with other people online quite seamlessly with this old title. And so the community at large, this is like one of the largest esports titles out there, has like moved in droves towards this
right.
new platform to compete. And again, running tournaments for this game, exchange like there's professionals that are working with this space, and it's actually so interesting. I think it's very endemic of kind of your name as new technology, like the emerging technologies group, because that's kind of what this is. And it feels like the governance and the law has to kind of catch up to what's happening
Yeah.
right now. Because what happens now that there's professionals that are sponsored by established organizations to compete in this game, but this game is played through like this
Right.
gray area of legality.
And again, I think where our conversation ended up between Alex and I was that it's really going to come down to the community and which are the developers that support the community. And it's going to become very clear in the end. And they're going to have a choice to make. Are they participating in the esports community or are they not?
Mm,
And someone, and maybe it's going to take a challenge by big associations like World Gaming Associations to
mhm,
say that these aren't the things this is supposed to protect.
mm,
But at the end of the day, traditional law, and I'll let Alex weigh in on this. I think what she was trying to explain to me, that in traditional law, the platform would be protected, so the streaming platform developed, the emulator would be protected by the original developers and authors of those pieces, but it wouldn't negate the fact that there's still copyright infringement of the
mm.
game itself while it's being played on these platforms. But it's very unfortunate, like you say, because otherwise this copyright has very little use or value.
Mhm.
Yeah, I would definitely agree with that. And, that kind of brings in the issue too that things like emulation hardware is something that you can retain a patent over. Whereas there's a bit of an intersection between copyright and patent when we're looking into software and that kind of stuff. Whereas traditionally, software is covered by copyright, whereas the hardware is copied by
Mm,
patents. So
mhm.
that's where that issue is then brought in because they're different types of ownership.
Yeah, I guess this ties into even if it's a very traditional game like that's supported by the developers. So in this case, we can say Riot with like League of Legends, where they're explicitly supporting the esports space. But at the end of the day, it's the publisher themselves that owns that title and owns that game.
Mhm.
So can you even touch on if a grassroots community or a school or post-secondary institutions wanted to run their own tournaments and then are paying people out and earning money and income off of their property, or in addition to just these streamers, right, streaming these games and earning an income off of these games, how much control and power does the original publisher have? Can they just pull the plug completely? I think that's a even with League of Legends, it tends to be very finicky with some of the larger esports titles like Rocket League and others, where they're not going to formally recognize the event unless it's from the publisher themselves. But then there's some cases where it's kind of a fine line because the publisher doesn't explicitly want these events to happen to begin with, which again, a good call back to Melee. And so these schools and communities are running these own tournaments for this title without the explicit support, and at any time could they just be shut down?
I mean, the answer is always it depends.
Yeah.
And, within copyright, there is exception for something called fair use. Whereas if we're looking at like universities and schools,
Mhm.
and they're using materials for a learning purpose, then it could fall within the spectrum of fair use. But when we get outside of that, that's where things get a little bit trickier. And the copyright owner doesn't want it to happen, they're going to make that known by sending a cease and desist.
Mhm.
But then it is kind of a fine line, and a lot of it is going to be notoriety that kind of plays into it.
Mhm.
The the wave made by the event, the louder the noise, the more likely it is that, this copyright holder is going to look into it and be like, is this an infringement of my, artistic rights, and do I want to act on it? So it does, at the end of the day, it depends, and I can't really give a definitive answer on when they will enforce it. It's up to the owner of that right.
Yeah. And I think it comes back to that same premise. Are you a supporter of esports? Or are you someone more concerned about controlling the industry for your own gain? I think my view is that with the emergence of technology, cross-jurisdictional issues, the whole point is to benefit as many people as possible while everyone gaining some kind of benefit from it. So if you're playing a game that was developed by anyone, I guess, you're promoting them inadvertently for free. And so you would think that they would want to participate in that event and help in the promotion of it instead of, cease and desist and tell you not to use it. And so I think it comes back to what Alex said about being maybe a bit more proactive, reaching out and developing these relationships with developers that you feel you have support from, so that you know that there are places where you won't run into this in any event, that it's low risk. And, another question that I'd asked Alex is, well, what would be the worst that can happen? What would be the cost to these parties if they were successful in finding that you'd infringed on their copyrights? Just taking, for example, someone playing a game on Twitch and people watching, how much would they be sued for if they were playing a game that they didn't have the right to be playing on a YouTube channel or on Twitch? And what could they be worried about? And I think that's a live question, because in certain cases people are winning millions of dollars, but in other cases it's very difficult to measure the monetary value that they're gaining.
And that was like a very significant problem at the kind of early stages of YouTube and Twitch, where people were themselves playing through the game and getting their YouTube videos taken off YouTube for copyright. And again, people there's livelihoods tied to these activities, and so it's certainly challenging. Would you?
So
sorry, go ahead.
No, I was just going to say, I'm not sure where we are in terms of time, but I just wanted to make sure that we had a chance to make sure your community knew about the major change that's coming to the gaming laws federally and in Alberta. The federal government just recently changed the criminal code. So previously it was illegal to bet on a single game. And so that's been lifted out of the criminal code now, which then allows provinces to regulate and allow for single game gambling. So that happened on August 27th. 2021, and now we can look to the AGLC for how organizations like AESA can allow single game betting.
Yeah, that brings up a great point too. Well, I know we're kind of close to time, but I want to kind of share this sentiment. Myself and Brad and many of the folks within communities have been playing these tournaments and competing with money for over a decade, or even just the last couple of years, and it always felt like we were walking the line of are we gonna get shut down by AGLC? Are they not gonna recognize this as a skilled competition? And it's, while all this is happening, the kind of the over-encompassing stigma of video games and esports is also something that we're trying to advocate for as well. And I think once governments start to recognize that this is a legitimate industry that's forming, and even for law firms like yourselves to realize that this is beyond just kids playing in their basements for spare change, and that there's a genuine need for governance and structure and guidelines in place to actually have this built sustainably.
Yeah, I think that's definitely happening, and we've seen it in so many places, just as we mentioned, with the criminal code changing, with the AGLC partnering with different partners to set up internet esports gambling for within Alberta, whereas previously billions of dollars were going to foreign sites where people could gamble outside of Alberta and Canada, but not in Alberta or Canada. So that's going to change. And we're also seeing big changes that will come to the copyright, trademark, and patent laws, particularly with the Copyright Modernization Act that's being worked on right now. And that's more so to address where AI is coming into the picture here, but I think that will massively impact the world of esports as well, as they discuss who is the author, what's, what does skill and judgment mean when you have computers involved. And so I would strongly encourage AESA to get involved in those consultation processes, because hearing from the communities that are impacted by the changes to these laws are so important. And that's what we're trying to do with our emerging tech group. So definitely we'll be keeping our eye out for all of that and notifying you immediately.
And that's why we exist, everyone. That's why the Alberta Esports Association exists. So we have some level of structure to provide some sense of governance in this space, especially because we're navigating in this new, emerging, and nascent space. It's confusing for everyone, but I'm so thankful that we have the two of you to support us here on this initiative, and I'm just so looking forward to working with you two again, and to do more of these panels and to talk more with the community and to have you share your thoughts.
And this is just, the tip of the iceberg. I feel like
I know. I want to keep going.
I have things about patents, trade secrets. There's so much to talk about.
There's so much to talk about. Yes.
Yeah, we're so excited and we can't wait. We hope everyone has a great time at the event.
Yes. Thank you, everyone. Thanks so much.